Well, welcome back to From the Couch. Lewis, nice to see you again.
It's been a while, but good to be back.
It has been a while. It's been a pretty hectic end to the financial year, and I hope your business has gone as well as you wanted it to go as you got to 30 June. Well, I think last time we spoke to you, we discussed some mooted changes to the Fair Work Act that the government were hoping to bring in, and a lot of that's actually occurred coming up to the end of the financial year. Well, I think there's probably three we should talk about. The new bullying laws coming in 1 January 2014. There's the flexible work arrangement changes which have come in 1 July, and probably the changes to the union right of entry provisions, which are not going to affect everybody, but certainly those people with unions involved in their business need to be across. Well, from the 1st of January 2014, the Fair Work Commission can hear complaints alleging bullying in the workplace. I think importantly we should just start with exactly what bullying means in the context of these changes. There's three tests for it to be bullying. The first one is it has to be repeated behaviour. The second one, it has to be held to be unreasonable. And the third one is it must actually pose a risk to health and safety. Well, let's say you fall into that category, Lewis, and a complaint's made to the Fair Work Commission. What can happen in Fair Work?
So Fair Work has to deal with the complaint within 14 days. So that means they at least have to start dealing with the complaint. And Fair Work doesn't have powers to issue compensation orders or to issue fines or anything of that nature. But what they can do is issue orders that compel an employer to stop the bullying that's occurring in the workplace. The power to issue orders is very broad.
So it is very broad. Are there any guidelines for the tribunal in terms of what it can and can't do?
The provisions of the Act don't really have guidelines about what types of orders should be made. It's very broad in terms of just orders to stop the bullying. So you could imagine the Commission will take a look at the circumstances in each case to determine what's actually necessary to stop the bullying, but there's not going to be any restrictions in the Act on what the Commission can or can't order.
I think the takeaways for me probably, Lewis, are I think companies are going to have to probably move a little quicker than they might have done in the past about bullying complaints. I suspect that they're probably going to have to institute investigations a little earlier than they might have done in the past. And I think the big concern I've probably got is to make sure that managers don't stop actually managing their people for fear of actually being hit by complaints. They've just got to keep on doing their job to manage their people and manage their business properly.
Certainly.
So, right to request flexible work arrangements have changed. Any material changes?
Yes, certainly. We started off, when the Fair Work Act came in, with a right to request flexible work arrangements for parents who had children under school age. Or the Act also allowed people with children who had a disability up to a certain age to also request rights for flexible work arrangements. That's been extended quite dramatically. Now all parents with children of school age, so that is presumably up to the age of 18 for most people, have a right to request flexible work arrangements, and also all people over the age of 55. So that's quite a broadening. There's an additional protection for people who've been the subject of domestic violence. They also have this additional right.
The right to refuse still based on reasonable business grounds?
That's right. So although you have this right to request flexible working arrangements, all employers are entitled to refuse that request if they have reasonable business grounds for doing so.
I think lastly, union right of entry. There's been a lot of debate over the last 4 or 5, 6 years about unions' right of entry, and in particular where the union can hold its meeting with its members or potential members. There's a change there as well.
If the employer and union cannot agree on the place where the meeting should take place, then unions by default have a right to meet in the place where employees ordinarily take their meals. So what most employers would be a lunchroom.
Well, a lot of changes. Please have a look at the alerts on our website. There's further information there. I hope your business goes well for you, and cheers until another episode.
And go the Blues!
Absolutely.